Hello, my name is Ryan Thibodeau. The case in which I'm discussing is the OCR, uh, also known as the Human Services Office for Civil Rights versus Hartford Allergy Practice in Hartford, Connecticut. Uh, this case started back October 6th of 2015. The reason why I chose this case is there's a physician in this practice that has a blatant disregard for a patient's own personal and private health information. And from what I can tell, even after I'll get into it at the end of the study, but even after he was told to not disclose any information to the press, he did so anyways, and the only reason why I could assume this would be to have his name in some sort of paper, whether, they say no publicity, any publicity is good publicity. Well, it's not necessarily the case, and, you see a lot of these doctors have some sort of a God complex, and I was always curious as to how the press received some of this information mere hours after, say a death occurred or anything along those lines, as somebody was arrested. And you know that if you've ever lost a loved one, that the cause of death or anything along those lines, it takes weeks to come back. But somehow a reporter is able to get this information quickly from just calling the office. And them knowing that that's not the patient they're speaking with, but the information is still released. Uh, Anyways, some of the details in regards to the case. Back in October 6th of 2015, the OCR, the Office for Civil Rights, received a complaint um, that a individual was turned away from this practice because their service animal was with them, and it is an allergy office, but again, it's a service animal. There's a reason why that this animal is with them. People with service animals do have allergies, believe it or not. And this individual called the Office of Civil Rights to file a complaint, and at that time, the um, complaint was filed with the office, and the news got wind of this complaint via complaint records with the courthouse and different legal documents. And when that happens, the press contacted the physician's office, and at that time the MD started to disclose some of the individual's private health information without permission from the patient, which the privacy officer, before the physician spoke with the press, the privacy officer knew that something was going to come up and something was going to get wind of this, and told the physician if for some reason he absolutely had to make a comment, the comment was to be no comment, or just to not accept phone calls from the press themselves. It turns out that after the investigation was concluded, they were found in violation of the HIPAA privacy rule, 45 CFR 164 subsection 502A. Now, what that does state is subsection A is a standard. It's a covered entity or business associate may not use or disclose protected health information except as permitted or required by this subpart or subpart C of part 160 of the subchapter. And it just goes on. And basically, the subpart they're pertaining to is the individual and the patient in this case. They did not have that permission, and it was a blatant violation. The office admitted to it. Well, they paid a fine without admitting liability. So this is their way of, saying, okay, you know what, we'll just brush this under the rug. Here, they had to pay a $125,000 fine, and they had to agree to be monitored by the OCR and their practices compliances for 2 years, in which they were going to be monitored for that time point. The responsibility of the compliance officer in the situation was exactly what should have taken place. The physician, the privacy officer told him not to make a comment. It's not your place. We do not have a permission from this patient to speak with anybody else in regards to their personal health information. But once something happened and he did release that information, then they were kind of stuck and they couldn't really wiggle out of it. They didn't accept liability, but they did go ahead and pay for it, which, in this case, if you're going to pay for it, you might as well just claim it as it is. It's just not claimed on paper. Personal thoughts. I'm assuming the doctor just wanted his name up in black and white, thinking that it's good publicity because it's some publicity. I couldn't find anything in the future in regards to where he's at now, or it doesn't give the physician's name. It just says that the practice continued to be monitored for those 2 years. I found this information on the HIPAA violation of the Specific Privacy Act. The subsection was at the Cornell Law Library at law.cornell.edu CFR/text/45/164.502, which will be in a Word document. And as the actual case I located was the HIPAAjournal.com. It's an online database of different HIPAA violations that have been noted over the years. Thank you very much.